Muted.
Good afternoon. We are about to start the webinar on HIPAA, a closer look. I'm thrilled to present our presenter today, Michelle Bilski, who is a highly rated speaker on healthcare industry-related topics. She's going to be leading this webinar and holds a certification in HIPAA. She is licensed as an insurance agent and has been recognized and approved to provide CME credits for her lectures. She currently heads up the Orlando office for Danna-Gracey, which is the #1 independent medical malpractice insurance agency in Florida. And with that, I will introduce Michelle.
Good afternoon, everyone. So thank you very much for joining our webinar, and we'll go ahead and get started. If you have any questions, you can type them into the computer there, and we will get to them either as they come up or at the very end, just kind of depending on how we're doing on time. So let's get started with, what does HIPAA mean? Most of us who are in the industry for a while know that HIPAA is the Health Insurance Portability and Accountability Act of 1996, so it's been around a long time, but has undergone some changes over the years. It's a federal rule, so it's covering healthcare and health insurance industries, and it's across the country. It's not state by state. Under HIPAA, patient privacy is the concern of every healthcare employee. So this is not just an entity concern. It's something that needs to be communicated to all employees so that it's everyone. It's a culture within the practice, not just a rule or something that the practice itself has to follow. HITECH was what came around in about 2003, and that stands for Health Information Technology and Economic and Clinical Health. It expanded the privacy and security provisions and the penalties to business associates with HIPAA. So we're going to take a little closer look at why HIPAA came about and what we have to do to comply with it. HIPAA came about in general terms to improve healthcare. It standardizes how insurance claims are processed. It's making sure that health information is transmitted securely, and essentially the #1 goal is to protect the privacy of patients. There are 2 sections to HIPAA now. It used to just be the privacy, but now there's security with the advances in technology. You have security and privacy. So the HIPAA security rule covers information that's stored or transmitted electronically. So anytime you're using the internet or private computer networks, that falls under the security rule. The privacy rule covers health information in any form. And those are the significant differences between the two. So we're going to start with patient privacy. So patient privacy is everyone's concern. It is a basic part of patient care and has been for as long as doctors have been practicing. No one's running around and advertising anything about their patients. However, now it's just become more formalized. So there's standards for privacy of individually identifiable health information, and that's what it's called. It's the privacy rule for short. And then HIPAA, again, became law in 1996. The privacy rule of HIPAA took effect in April 2001, and of course all covered entities had to comply in 2003. Then that's the privacy portion of it. So sticking with that, the privacy rule applies to most healthcare organizations that hold or transmit personal health information. So private doctors' offices, hospitals, laboratories, pharmacies, radiology centers, home health, billing services, and any type of insurance organization or HMO. And then that extends now into CINs, ACOs, IPAs, any organization that maintains any type of private health information, whether that be for data collection purposes, like an ACO might have an exchange of data, or if it's just an individual provider's office that just has their patient's data. So the extensions are all employees have to keep the information private. And businesses, so the business associate agreements, businesses that work with the organizations that have any type of access to the PHI also have to meet the rule standards. So that's kind of the basis that a lot of players are getting into trouble now is with business associate agreements. I think that everybody probably has heard of the Raleigh incident up at the orthopedic clinic up there, where failure to sign one business associate agreement caused a $750,000 fine. And so the things are being looked at now when we're looking at complaints for HIPAA violations. In 2003, when this became law and everyone had to follow it, there were about 4,000 complaints. In 2014, there were almost 18,000 complaints. So it is going up every single year. Between 2013 and 2014, there were an additional about 5,000 complaints. So it was going up steady up until that point, and then over that 1 year period, all of a sudden there's a tremendous higher number of complaints. So it's definitely something that every practice needs to be aware of and comply with. What does the privacy rule allow patients to do? It allows them to see and get copies of their health records, and there are a few exceptions to that. One of those exceptions would be if there's something in their health record that might cause them to commit harm to themselves, if it's a mental health issue or something that that the provider feels they would be at risk of harming themselves, they can exclude that piece of information from the health record, and that's at the provider's discretion. They can ask for corrections or what's called amendments to their health records if they see an error or, quite frankly, if they just don't like something that's in there. And there's a form for that, and the practice has to give them the form to amend their record, and they have to respond to that within 30 days. So they take the form back, the provider looks at it, says, yes, I agree with the patient, that was an error on my part, and they have to, in writing, respond saying they are amending the record and provide them with a copy of the amendment. If the provider chooses not to amend it, and they don't have to amend it, they will have to provide notification on the form, send it back to the patient saying, no, I've denied your request for an amendment. The patient has the right to find out and limit how their personal health information may be used, and they have the right to ask for an accounting of disclosures, how their information was used in the past, who was it sent to, and for what purpose. How serious is this? This is very serious at this point. An organization can be fined each time it breaks the rules, and the fines for just the simple not reporting a breach starts at $1,000 per day with a maximum of $500,000 in fines. An individual, an employee, can be fined or sent to prison for willful violation. That's important for all of us to let our employees know that it is considered an offense, a criminal offense for them personally if they willfully violate HIPAA. It's not just the practice's problem. The HIPAA privacy rule sets a minimum standard for keeping information private. So some states do have stronger laws, and Florida now does have one. It's called HIPAA. It has some stricter guidelines. It's the Florida Information Protection Act. That was enacted for every Florida business that has private information, which would include name, phone number, social security number, dates of birth, not just medical information, and that has to be followed. So for practice, any kind of covered entity, they now have to follow both laws, HIPAA and HIPAA. So the HIPAA privacy rule requires certain processes that we follow. Those processes have to limit how the personal health information can be used. It requires security of health records in paper, electronic, or other forms. So keeping in mind that it's called the high-tech rule now, it's the HIPAA privacy and security, it still covers any and all paper documents in addition to electronic and any other type of form. Letting patients know what their rights are, They have the right to see and obtain copies of their health records, again with a few exceptions, ask for corrections, find out, limit how their personal health information can be used. One of the things that I found very interesting, I was doing some research, and the most common breach for HIPAA is the impermissible use or disclosure of PHI. And then in the top 5 is also the denial of patient access to their own PHI. That is the third most common breach of HIPAA, which most of us would say that's insane. Of course the patient has a right to their access, but is the third most common breach. So somewhere out there people are denying patients access to their own information, and it could be something as simple as a fee. They're charging a fee and it's coming back as being denied even though they have a right to charge a fee, but that is the third most common. Well, the next thing we're going to discuss is what is protected health information. So PHI is health information that applies to any health condition now, in the past, or in the future. And if the health information, it includes any data that would let somebody identify the patient. That's the key to the whole thing. It's individually identifiable. So anything that can identify the patient is then considered protected. For example, X-ray reports, lab reports, other test results, prescriptions, health insurance claims, and billing records. So anything that has the patient name, that has their ID number, information about his or her health, those are all considered PHI. Let's define what disclosure is. Disclosure means to give out the PHI. So providing information about a person for the purpose of billing is an example of disclosure. Now the question is, does that require an authorization? Actually it doesn't. It requires consent, which is part of the intake paperwork that you get, giving the consent to use health information for the purposes of treatment, payment, or operations. So TP and O are the 3 key things that you don't require authorization, just consent. Talking about a patient's condition in a public place, that is another example. And then what's incidental versus breach? So incidental is when you're doing something that happens in the course of business. So you're taking a patient, or the MA is taking a patient out of a room. They're walking them to the checkout desk, and the patient has a quick question on what does this medication do. If you've already filled that room, there's nowhere for the MA to go, so lowering their voice and saying, oh, well, the doctor prescribed this for blah, 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 very quietly. That's an incidental. If somebody overhears that, it's incidental. They did everything they could to avoid a breach. That's the difference between the two. So let's talk about the key pieces of the HIPAA rules when somebody comes and say they're going to do an audit. One of the first things that someone from the OCR would ask is, what is minimum necessary? It's a key component to HIPAA. Minimum necessary is very simple. It's exactly what it sounds like. It's the minimum necessary information to do the job that needs to get done. So a good example is, typically you say don't ask for more information than you need and don't provide more information than somebody else needs. One of the things that we look at, or that the OCR looks at when they do audits, is if you have a front desk person who only sets appointments, you're a large office, everybody has a designated skill set, a designated position, and they only set appointments, they should not have access to clinical data. And that's very important to make sure that every person has only the information they need to do their job, and that they only access the information they need to do. And then they limit the information that they share with a person to do his or her job. So those are very key components to passing or not passing an audit. The next key component that an auditor would look at is reasonable safeguards. So every practice has to have a written notice of privacy policy that needs to be posted in the front office. It needs to be available on their website if they have a website. All employees must know and understand the HIPAA privacy rule. Requires annual training of all employees. All employees must make every effort to keep private information private. So like we discussed before, incidental, lower voices when discussing patient information by checkout desks or nurses station. Never ask a patient for personal information in public, including at the check-in desk. Turn papers upside down so that information can't be read easily. Those are all things that are considered to be reasonable safeguards. It doesn't cost the practice any money, and it's something that everybody should be doing. Again, that culture of compliance for the practice. Intent is a lot of what auditors look for. If the practice intends to keep patient information private, then there's action plans that get put into place if there are violations found versus fines that could put into place. So again, that culture of compliance. Let's talk about the written notice of privacy policy. So there's very specific things that must be in that privacy policy as of 2013, as of the changes in the law in 2013. The privacy policy must say that the organization must protect the privacy of the patient. It must say how the office can use or disclose PHI. It must say how the office keeps the information private specifically. It must say what the patient's privacy rights are. It must say how to file a complaint. That's the biggest breach that I see when I go around and look into different offices, is that it has, the privacy policy is wonderful. It says a lot of things about a lot of things, but it's missing how to file a complaint. That is very, very, very important. It must be posted in the office waiting room area, and a copy must be offered to all new patients, and they required to have them sign that they read and were offered a copy. So that's very important, because I go into providers' offices that simply says, they have a form that says, I've been offered and I have read the privacy policy, but they were actually never handed one to read. So it's very hard to justify them signing off saying they have read it when they never were provided. Now, there's practices that provide a laminated copy because it saves on copies. They let the patient know that it's available on the website, or they can give them a printed copy right there. You don't have to give everybody a printed copy, but you do have to have one for them to read, so when they sign off on that page, even if they choose not to read it, they actually had a copy to read. So that's a key thing for everyone to be aware of. Moving on to PHI. So let's talk about that. PHI is any health information an organization has or gets from another organization that could be used to identify a specific individual. So we need to pay close attention to information that gives details about who a person is. So you're sitting in the waiting room, and the nurse or the provider comes out and announces your name. Michelle Bilski, it's your turn, come on back. And that's fine. That is not breaching HIPAA. In the past, or when the law originally came out, there was some questionable that, because two pieces of information must be provided in order to breach HIPAA. So there was the assumption that if the patient is in the doctor's office, that already is one piece of information. That has not held up. So the fact that they voluntarily came into your office does not hold up as already breaching one, as already providing one piece of private information. That is their choice to come in there. So saying their full name does not give two pieces of information. So it's okay to call out their full name. It's okay to have them write down their full name on the list of patients. So they come in, they check in at the front desk, they write their full name. You don't have to hide that. You don't have to cross it out. You don't need any peely labels. That's okay. But you can't ask anything else other than yes or no on that same write-in form. So if you ask for their address, now you have their name and address, that's a violation. Phone or fax number, you can't have them write that down. Social security number, license plate, driver's license number, date of birth. Any of those things combined with a name gives those two pieces of information. So you want to stay away from anything other than yes and no questions on that sign-in sheet. So that's the answer to how much information constitutes a breach, two pieces. So the privacy rule covers PHI in any format, written, spoken, electronic, and PHI takes on many forms: medical records, a prescription label with the patient's name, date of birth, and name of the drug, doctor's notes about a patient, an x-ray, a letter giving patients test results. One of the things that we have to be very aware of is that a patient cannot violate their own PHI. So we need to make sure that our staff is very diligent in stopping themselves from answering a question in public. So a patient can be sitting in the waiting room talking about all sorts of things. They can be talking about their recent STD test. They can be talking about, all the things going on in the villages, whatever they want. They can talk about it. But the minute we as providers respond to them in public about a question, a personal question, we have violated HIPAA, even though they've been talking about that for the last hour in the waiting room. That's probably one of the most difficult things to get across to our staff, that they have to stop the normal reaction of responding to a patient in order to be compliant with HIPAA. And that's a very big, real problem that we do have in the practices and doctors' offices, and in hospitals. It's getting bigger and bigger. Let's talk about some just very simple ways of excuse me, keeping PHI private. So there's certain easy things we can do: locking filing cabinets and file rooms where charts are stored, logging off computer systems that contain any kind of patient information when someone walks away from a computer. This is also one of the big things with any of the practices and the patients. Okay, you've got a staff member that just gets up from their desk for a second to grab a piece of paper off the printer. Technically, no matter how long they're away from that desk, if somebody can come by and see what they're doing and there's patient information on the screen, it's a violation. Screens, putting the protected screens covers on, that is a great way to maximize the use of staff time so they don't have to keep shutting down their computer while still being in compliance with HIPAA. And then shredding any documents that contain PHI. So those are all great ways to keep PHI private in the office. Then when you're actually using PHI in the office, if it's used publicly, just don't use any more than necessary. Again, we kind of went over this already. Sign-in sheets, calling out a patient's name in the waiting room. Just make sure that that's all that you ask for, is just their name. General disclosure information. So basically, when can you disclose PHI? And a lot of this is without an authorization. So you can disclose it if it's required by law, a court order. You can disclose it to public health officials to prevent or control disease. In any case of abuse or domestic violence, to help law enforcement officials, to notify law enforcement officials of suspicious death, funeral directors, coroners, organ donation. And then, of course, government actions to meet workers' compensation laws, and then, of course, in disaster relief. Now, in most of those cases, specific conditions do apply, and one thing that should be noted is you're allowed to, but not required to, share that information in most of those cases. So you can without an authorization, but you don't have to in many of those cases. And we can, if you have any questions on that, you can let me know offline. But those are some of the things that's good to know. Authorization to disclose information. So essentially, authorization is permission to use the health information. It must be in writing, and it must include specific details about what information can be used, how it can be used, how long it can be used. No authorization is valid for longer than 1 year. So the general information you collect when you're updating patient information, it's a new patient, they come in, they sign all of the forms, that authorization is only good for 1 year, which is why when they come in the next time, everything, if they're, you know, just an annual visit kind of person, that's why you update the information each year, and it gives you a very good, easy way to say to a person when they say, but I filled that out already. It gives you an easy way to say to them, yes, you did, but the authorization, because of HIPAA laws, is only good for 1 year, so I do need you to verify all of this for me. And that's a great way to make it nice and easy. And then generally, patients can change their mind about the authorization at any time, and they do have to notify you in writing of that change of authorization. They can't just call and say, hey, I changed my mind, you can't use my information, or my husband can't access my information, or my child can't access my information. They do have to put that in writing to you, which is a good way for us to protect ourselves as providers. Knowing when authorization is required. One of the goals of the privacy rule is to allow patients to have more control over how their health information is used. So you have to get authorization before providing information to an insurer or other business for marketing purposes, not to get paid, so not for billing or operations, but for marketing purposes. You actually have to get authorization before sending the results of a pre-employment physical to an employer. So if a patient comes in with their pre-employment physical form, make sure that they also have that it's signed at the bottom saying I authorize this to be sent to the employer. That's very important. That has also resulted in some violations. So need to make sure that that additional thing is added. Now, what's the difference between authorization and consent? Consent is less formal than authorization, and consent includes what we all know as implied consent. So you can just get consent to include a patient in the directory of patients, to share the information with the patient's family or friends. So this is an interesting one. If a patient comes in with their daughter to a visit, and after that, and they're not on any authorization form, they are not on the HIPAA form, but that patient's daughter, it's noted in the visit notes that patient's daughter attended visit with them. They were in the exam room with the patient. That person has the right to information about that visit only. So if they call and say, we forgot how many times my mother should be taking this medication that was prescribed today, they can be answered, even if they're not, again, not on the HIPAA form, just for that visit. If they call and say, well, I need to know what the original dosage of this prescription was 6 months ago, unless they're on the HIPAA form, they don't have a right to that information. So it gets kind of complicated. My advice to everyone is always, if a patient comes in with someone who is not on the HIPAA form, ask them to add them to the HIPAA form so that if they would like to have access to all of their health information, it just makes it cleaner and easier. And then use information in ways allowed by the privacy rule. So, again, TP&O, treatment, payment, and operations. EMRs and electronic data interfaces. So any kind of electronic transfer of information, whether it's through email, computer-to-computer faxing, other means, all of that is covered under HIPAA rules that deal with security. And the organization must make sure their systems, their computer systems, and how they're using them meet the standards of the security rule. So this gets a little bit more complicated. The HIPAA security rule, on the next slide, states that every organization has to have its own rules for storing information, transferring information, and EDI. And some of the key parts to every organization and to their rules should be using a password and making sure that the employees change it often, requiring logging off of computer systems when the staff leave the computer. The best is always an automatic log off, just so that way you're sure that if the person forgets to log off, within a specified amount of time, usually 2 minutes, the system logs them off itself. Don't allow the use of external drives such as USBs or phones to be plugged into work computers. So that's also one of a huge discussion now, because anything that contains PHI has to be encrypted. So whether that is a laptop or a USB drive that has any kind of PHI on it. Some of the other recent fines, there was a Florida practice that was fined $750,000 because of an unencrypted laptop that an employee or provider actually had taken home and got stolen. And it was not encrypted. Encryption means that if somebody cracks the passcode and gets into the computer, that the data is not readable. That's really what encryption means. It's not just having a passcode on the computer, but that the data can't be read without specific security requirements, and that applies to USB drives too. So if somebody breaks in without the proper, they backdoor in, let's call it, without the proper login, that the data in there is totally unreadable. And then, of course, unencrypted emails, that's a very difficult one for all of us to follow because of how much information we utilize and how much data goes back and forth and how often we're emailing things. So if you do anything with Aetna or anything like that, you have to get some I think I usually get this is an Aetna secure email, and you have to go into the cloud and you have to put in your information and you have to put in your password, and it takes a lot longer than you'd like it to take, but that's how encrypted emails work. And so that is the key to making sure that that's all safe. So security rule procedures, how do I stay compliant? There's a couple really simple things to do. So turn computer monitors so they're not visible to people walking by. Use the screens on any kind of computer monitor that is in a high traffic area, even if the monitor is not readily visible. Here's an interesting one too. Disposing of old equipment and storage devices, so disks, CDs, I know, don't laugh. There are still offices that use disks and CDs. And properly document that they have been disposed of. So that is a key requirement. If you no longer can you just wipe the computer clean and donate it to charity. You have to document the serial number. You have to document the date it went in service, the date it went out of service. You have to document that the hard drive was completely wiped. And then you can get rid of that piece of equipment. But it has to have the proper documentation so that anybody who's tracking that can see that you did everything according to the HIPAA rules in order to keep privacy as the most important thing. And you have to have a security risk assessment, and it needs to be updated annually. And just so everybody's fully aware, security risk assessment is not the same thing as the meaningful use security risk assessment that is in your computer that most of us have done when we first qualified for meaningful use. It is, many portions are covered under that SRA, but anybody who has EMR will also know that that SRA says on it that it is not HIPAA compliant and that there are more components. So it gives you that warning that it's not the full and final authority on that. So that's very important for everyone to realize that that's not the one and only. When we're looking at the basic things for HIPAA and privacy, so essential things to know. Use only the minimum necessary information to get the job done. Only the PHI needed to do your job, and anytime PHI is shared with others, provide only information the other person or organization needs. Make sure you have business associate agreements with anybody who is going to have access to PHI or even incidental exposure. So for example, you have a cleaning company that comes during the day when there are patient files sitting on the desk, or you have your lab comes in and grabs samples that are going to the lab during the day. you need a business associate agreement with anybody that is going to have incidental exposure. You need a business associate agreement with your shredding company. That's a pretty common one and an easy one. But those are very, very important. You need to the rules that limit access to information based on the employee's role within the practice, and that also has to be documented. There's about 34 forms now that must be in your HIPAA compliance book. That is the request for amendment, the right to access, the denial of amendment, the request for authorization for accounting of disclosures. All of these have a separate form that must be included within your book and must be utilized by the practice if somebody requests this information. Restriction, one of the other ones is I see a lot of violations on is restriction of records. So if a patient comes in and pays cash for a visit and says they want to restrict the information from that visit, that it's not to be disclosed to anybody, they have the right to do that. And it can't be disclosed at any time now or in the future. So if somebody does a full patient transfer, they're leaving your office, they're going to a new provider in a different state, and they request, the new provider's office requests all the records. If something has been restricted, you cannot release that one piece of the record. Another question I get a lot of is things like, well, am I allowed to provide the patient with records I receive from other physicians? So here's the catch with that. Yes, if a patient is getting their own record, they have a right to everything in their patient record, which includes any information that you have received from other providers. However, if you're requested for records from another provider, then no, only the records that you have generated in your office are the ones that you provide to another provider. So that adds another layer of complication to the rule. So I'm the patient, I come in, I say I want my full record. I have the right to access everything you have in my file, including records from other providers. I am now the new provider, and I send an authorization to release records that I'm now the new treating provider. And no, only the records generated by your office can be released. No other cardiology notes, any orthopedic notes, nothing that's in the system that was not generated by you can be provided. So there are some complications to the rule that have been interpreted recently. So briefly, corrective action plans. If somebody comes in, now I think everybody's aware of the audits that are coming on. There is a pre-screening questionnaire that should have been received by most practices by now. They're in the first phase of the audit. So basically, the pre-screening questionnaire is just sending to all of the practice managers or providers that are on file with a OCR, and it's basically asking to confirm their information, that they do have the right contact person, they have the right email address, they have the right street address, and that's really all it is. Once that pre-screening is done, then they send the second part of so that's the information verification. Then they send a questionnaire, and this is basically asking information about your organization. So you have a specific time frame that you must respond to each step in. And you have 15 days to respond to verifying the contact information. You have 30 days to respond to the questionnaire for the audit. And all that is are you a public, or there's like 15 questions. Are you a public or private entity? Are you a single location or multi-location? Are you a covered entity or are you a business associate? How many patients' visits did you have in the prior year? What type of facility are you? Do you use electronic medical records? So once you've answered, and I'm looking through the pre-question, there's actually 27, there's 30 questions, sorry, there's 30 questions. Probably less than half apply to each particular entity, because some are just, if you're just a lab, answer these. If you're just a business associate, answer these. but you have to respond to that. That is how OCR is going to decide on who is going to be audited. They are required to do random audits. They're required to do a certain number of audits. So they're going to use that to say who they're auditing. Now, in the past, it's been very simple. If somebody called up and complained about you, typically you got a call from OCR to request some information, and that's how you got audited. Now, based on your responses, they're going to select random covered entities that fit their parameters. They're going to, in Gainesville, Florida, they're going to pick 10 covered entities to audit. 3 of them are going to be solo providers. 3 of them are going to be multi-specialty groups. 2 of them are going to be large orthopedic groups. I'm just randomly calling things out, by the way. I have no idea who they're going to audit. But they're going to take that information, and that's how they're going to divide it up. They're going to audit those ones that they feel. The first step of the audit, there's 3 different ways to audit, but the first step of the audit is going to be sending an email out to the contact person and saying, please provide these specific documents. This is our preliminary audit of your facility. And so that's going to be the first thing. They're going to ask for your notice of privacy practices. And they don't want your entire HIPAA book. If they ask for your amendment, request to amend records form, they want just that form in a file. If you send them everything, they will not accept it. So follow their instructions very specifically, because if you can get by with just sending the documentation and not having to do an in-person audit, that will save a lot of problems. So make sure that you do send exactly what they're asking for. So that's step 1. In most cases, that's going to be enough to eliminate the risk of an actual in-person audit. And then the other is going to be a combination. They send you a pre-questionnaire, and they say, I want these things available on such and such a day at such and such a time, and we'll be there to review them. And then the third option is they just show up at your door and say, hey, I'm here to do a HIPAA audit on you. So those are the 3 possibilities that are going to be out there. A couple of other interesting facts. So there was just recently an $865,000 fine for employees looking at EPHI that they didn't have a reason to look at. So when I say make sure that you limit access to information based on the employee's role with the practice, that's one of the reasons why. So if an employee goes in and looks at somebody's chart that they don't have a reason to, and this particular fine was levied in California, but if they don't have a reason to go in and look at, there's always a record, especially if they're accessing it via hospital records. So if they're going in and they're accessing the hospital to get a surgical report, and they say, oh, you know what, my Aunt Sue was in the hospital. I want to make sure she's okay. Let me look at her record. Those types of things must be limited. They can't do that, and they need to be educated that they can't do that, and that's what generated that $865,000 fine. So there's lots more information and very good stuff on hhs.gov. But that pretty much concludes my presentation for the day.
Michelle, we have quite a few questions I can start running through, and we can see how many we get through. If you're ready.
Yep.
So we have one from Chris. If you do not participate in Medicare, does HIPAA apply?
Yes.
Okay. Another one from Chris. Do you have a form template for amendment of records?
Yes. So at the end of this, we'll give out my email address, and I'd be happy to send some forms around if you need the template for some of the forms.
Okay. And one from Debbie. I recently received automated communication reminder from the Office for Civil Rights regarding its potential inclusion in the HIPAA privacy. I'm not sure. Regarding its potential inclusion in the HIPAA privacy, security, and breach notification rules, I'm thinking I need to prepare. Does she do audit?
Yes.
Okay.
And yes, I would agree with her that she does need to prepare.
Does a full and just the insurance company name violate two-item rule on the sign-in sheet? So I guess does a full name and the insurance company name violate two-item rule?
I would say it's not. I don't know that I've ever heard that has been considered a violation, but I do believe to err on the side of caution, and I believe that you should ask, has your insurance information changed, yes or no, versus what is your current insurance carrier information? Because that hedges, again, remember they're in the office, so that is really one piece of information that OCR says not really. They've walked in there voluntarily. But then you add that with an insurance carrier's name and with the person's full name, and you're hedging on a line that I wouldn't want to cross. So I'd say you're better off not using the full insurance carrier's name.
This is one asking about, I guess, the requirements for having your computer off while you're away. And they're saying that their computer must remain on while I am away for billing. I cannot lock it. So what might their options be? The screen that you can't see, the privacy screen?
Well, then they need to be in a locked office. They need to lock the door to the office. If there is and I couldn't even possibly imagine why it can't be, the screen can't be locked. I don't quite understand the reason for that, but that's irrelevant. If they believe that you cannot turn your computer off, then don't lock the screen, but that computer and that function, whoever's doing that, you must be able to walk away and lock the door so no one can get into that room or computer if it is left unattended and on.
Okay. This is another one. How does requirement requiring written notice and signature apply to laboratories that receive specimens from clinicians? Do we have to supply written HIPAA notices in order to bill? Does that make sense?
It does. No. So if I'm understanding the question correctly, if you are sending a specimen for testing, I'm going to just use Quest and LabCorp as the just simple examples. If they're coming in and they're picking up the specimens and you've already had your authorization signed for the treatment, the patient has authorized you to provide treatment and care of them, then you don't need a separate authorization to send those samples to the lab. You do, however, need a business associate agreement with the lab.
Okay. I don't know if you'll know the answer to this one, but what if you were using Citrix on laptops? Isn't that safer since no data is on the laptop?
Yes. That is very good. As long as you have logged off of Citrix and it requires a new login, then yes, the data that we're talking about is if so the breaches that occurred with the unencrypted laptops and USB drives were because in the case of the one in Florida, which was in Lady Lake, the person had downloaded the actual patient data in order to review it at home because they did not have an internet connection. They thought it was more secure since they didn't have a firewall at home to download the data, take the laptop home so they didn't breach the firewall. Unfortunately, the laptop was not encrypted. So you're absolutely right. If you use a Citrix connection, then yes, the laptop doesn't have to be encrypted, just password protected.
Okay. Are the first three letters of first and last names adequate protection?
First three letters of first and last names, adequate protection. I think I need more information than that. I don't know if we're talking about a password, if we're talking about, I'd need a little bit more information on adequate for what.
Okay. Let's see. If I cannot provide old records for requested records, what about specialty consults? Does that make sense?
So if you have a specialist that's doing a consult, I think I understand the question, and I hope I'm answering it correctly. So you have your primary care, you're referring somebody to a cardiologist, and you want to know if last year you have to refer them to a different cardiologist than last year because the other cardiologist retired. Can you provide the old cardiologist notes? Not directly to the new provider, no. You can, however, have the patient pick them up and there's a very nice form that you can attach to it that says these notes were not originated in my office, therefore I cannot validate their authenticity. I don't know the entire wording off the top of my head, and the patient can bring those to the new consult. But it has to have that disclaimer that you didn't generate this, that it was provided to you by an outside office, and you can only give it to the patient, so the patient is also aware that and has reviewed that note to give to the new provider. I hope that answers that.
Okay, we have another question. Is there a time limit for a HIPAA security breach?
So there's lots of time limits on HIPAA security breaches. You have, if there is a security breach, you must notify the patient within 24 hours, and this is actually the HIPAA portion of it, is within 24 hours of your being made aware of the breach. There are two exceptions to that. So as soon as you're aware of a breach, if it's less than 499, if it's less than 500 records, so 499 records or less, and you conduct an internal investigation and you with your compliance officer, and it's determined that there is no likelihood of identity theft or misuse of that information. And my example for that would be there was a breach because records were inadvertently released to another covered entity. Both covered entities are required to conform to the HIPAA law. Then in that case, you are not required to notify the persons whose records have been breached. So there are a couple of exceptions. In general rule, you do have to notify any persons immediately if it's 500 or more. If it's less than 500, then it's a little bit, there's other caveats included in it. There is a reporting requirement to OCR for any breaches, so you have to notify OCR immediately for 500 or more. For 499 or less, you notify them once a year, and that is 60 days after the end of the fiscal year. So if you had any breaches of even one record in 2015, by the end of February 2016, you must have sent that report to OCR to notify them. Very long answer to a short question, sorry.
Okay, let's see. We still have a couple more. We log in remotely to access our specific workstation at the lab. If the laptop used to remotely access our work computer does not store PHI, does that laptop need encryption?
The laptop doesn't, but the methodology to access must be through a commercial grade firewall on both ends. So if you don't have a firewall, so that the fear is that the information can be accessed during transmission. So you can't be sitting at a Starbucks on an open Wi-Fi, and even though you're accessing the data behind a firewall remotely through Citrix or any other means, the fact that you're not on a commercial grade firewall on your end on the laptop makes it a violation. So as long as both sides have a commercial grade firewall, you're fine. It doesn't have to, the laptop doesn't have to be encrypted.
Okay. We'll take one more question. Let's see. From an attorney's office. If the patient restricts a certain date of service from their medical chart in writing, will the copy of the restriction be provided to the attorney so we will know they are holding that date of service back?
That is a very good question. So, no. So with the attorney's office, it kind of depends a little bit more on what the case is about. If it's for certain types of law, malpractice, workers' compensation, there's a variety of them that the restriction cannot be valid for. So I would need, whoever is at the attorney's office, please feel free to contact me directly on that question, because there's a little bit more of an extensive response to that than just no. What I tell you in general is that no, if a record goes out and there's a restriction, it's also assumed that the restriction is not told that there's a restriction. It's just as if that visit has never existed, but that does not apply to all cases of law.
All right, great. So Michelle, why don't you give out your information, and just for all the attendees, you will be getting a copy of this webinar, and if you need any other additional information, we'll have Michelle's contact information in that communication so that you can reach out to her directly and get more answers to your questions. But Michelle, why don't you go ahead and give how you would like people to contact you.
The easiest way is just shoot me an email to Michelle@Danna-Gracey.com. So you can see in the corner logo on your screen, DANNAGRACEY.com. So it's just Michelle@Danna-Gracey.com.
All right, great. Well, thank you, Michelle, for a great webinar, and thank you for all our attendees for your participation, and have a great rest of your day.
Thank you, everyone.